Welcome, everyone. We are here today on this beautiful afternoon at Seba Library to learn about wills, trusts, estate planning, and related matters, including Islamic estate planning. So, why is it important to know about these types of financial planning? It is very important because these are legal tools that help us manage and distribute our assets, protects our beneficiaries, and ensure that our wishes are being followed after our death or for some reason if we become incapacitated. These tools also help us avoid probate, minimize taxes, and help us with individualized and specific needs. With us today, we have, as I have mentioned, attorney Afsaan Reyes, who is a dedicated legal professional with a strong commitment to client advisory and justice. Attorney Raees has a comprehensive background in estate planning for individuals, families, and corporate and immigration law. Ms. Raees is licensed to practice in Georgia and provides personalized, strategic counsel tailored to each client's specific needs. Known for her integrity, diligence, and clear communication, Ms. Raees guides clients through complex legal processes with confidence and compassion. Attorney Afshaan Reyes has a multidisciplinary background with an undergraduate in computer science, an MBA from Georgia State University, and a law degree from Atlanta John Marshall School. This unique combination of technical, business, and legal expertise allows her to approach complex issues with a broad strategic perspective. Ms. Raees also specializes in Islamic estate planning, which we will be discussing also today. Without further delay, let's welcome attorney Afshaan Reyes.
Thank you.
To Seba Library. Our heartfelt thanks to Attorney Raees for helping us understand the complex and very important aspects of wills trust, estate planning, and how to safeguard our assets and ensure our wishes and that are followed in our absence. So before I go, just a quick note about today's program. It's very simple. Ms. Raees is going to do her presentation. It's going to be in English. And after her presentation, we'll have a Q&A session. So hold your questions. I hope there will be many for the Q&A session. And so I'll be back. And if there are any questions, if you want anything explained in Bengali, or if you feel comfortable asking the question in Bengali, I'll be happy to translate for Ms. Raees. So here we are. Attorney Afshaan Reyes.
Thank you very much, guys. I really appreciate the opportunity to speak to you this afternoon. The purpose of this session is basically public and community service to make you aware of things that you should be thinking about when you are planning your estate. And it is an important aspect of one's life because there are two things certain in life. One is death and the other one is taxes. You cannot avoid that. So let's start with the process of explaining what actually estate planning process consists of. So as you know, Quran is very clear on creating an estate plan and wasiya if you have assets. It is obligatory for every Muslim who possesses assets to come up with a plan, a way of distributing them on or after their passing. And this whole process is known as probate process in light of Georgia law. So the the idea here is that we function under the auspices of Georgia law, but incorporate Islamic rules for a lot of distribution ratios. And that's why it bears the name Islamic estate planning, because what we're doing is that we're incorporating in Islamic principles. And because the beauty of Georgia law is that it provides that option if you know the right terminology and know the right language to stipulate that. In Georgia, the probate process, so let's define what probate process is. The probate process is a legal process that an estate has to go through. The threshold for a estate to be probated is $15,000. If you have a estate more than $15,000, you are likely to go through the Georgia probate court. And this is the legal process where your will could be probated, and your executor will be provided with authority to make the disbursement according to the wishes stipulated in the will. But what happens when you don't have a will? There are a lot of situations in which there is no will. In that case, the Georgia law kicks in, and it is called the intestacy law. And basically, your estate will be distributed in accordance with the Georgia intestate law. So that's why I said, don't let state of Georgia govern what you're going to distribute your assets to. Make a plan, make it according to the wishes that you want your asset to be distributed. Be proactive about it. And the way you can do that is to create an estate plan. So how do you prepare your estate for estate planning purposes? Now, most of the time, the biggest asset for a lot of people is their residence, their primary residence. That is going to be determined by the title that you have on your property. You could either have tenancy in common title, you could either have joint tenancy with right of survivorship. The treatment is going to be very different according to Georgia law if the title differs. And that's why what you can do is that you can make plans and allocations during your lifetime to make sure that it is distributed and dispersed according to your wishes. Similarly, your bank accounts. What happens when you die? What happens to your bank accounts when you die? They're immediately frozen. Bank will immediately freeze your account if you are in an individual capacity until your probate will get probated through the probate court, and your executor gets the authority to manage that. So in situations where you are probating without a will, you're going to get letters of administration from probate court, and that is the authority that is sufficient to do everything on behalf of the deceased. However, when you have a will, you get something that is called letters testamentary, which is very similar to letters administration, but the distribution ratio that is applied in that is whatever it was stipulated in the will. So it is important to understand the difference between each type of instrument, each asset type. The goal should be that you protect your assets and keep your assets as much within the family, because you work really hard to create that wealth. You want to make sure that that wealth stays within the family instead of ending up with Uncle Sam. That is also important, that you need to consider how you can minimize taxation on your assets that you transfer to your progeny, to your beneficiaries, and in the proportion that, in the timeline that you are dictating, in the proportion that you are dictating. So it's it's very important to understand that. There are two types of things which are slightly different investment categories that do not come under your personal estate. Everything else that I talked about comes under your personal estate. And personal estate is something that will be part of the probate process, because once the Georgia Code begins the probate process, they're going to ask for an inventory of assets. The difference between 401ks and retirement accounts and life insurance is that there is already a pre-designated beneficiary for these types of investments. If you have 401k, if you remember when you were trying to open up and set up your 401k or your retirement account, they asked you for a beneficiary. So you named somebody already. But the problem is that sometimes you forget and you name somebody that you didn't want to inherit that money. And for example, in cases where there is a marital split, you named your ex-wife as your beneficiary. You don't want her to get all the money, but she will end up getting that money because this is who you designated the beneficiary as. So it's very important to keep stock of items that you have. And whenever there is a life-changing event, you should revise that. You should audit that plan. One of the things that we don't do is that even today, when we say we were very proactive, we created a will for ourselves 20 years ago, and we think that it's going to be applicable forever. Maybe it will be, maybe it will work, but there could be things that you want to revise. So it's important to keep on reviewing it, and revise it accordingly if there is a need for it. So again, going over the probate process a little bit more in detail. So what happens in the probate process? The probate process, as I mentioned, you will get letters testamentary or letters of administration, depending on how you probated it. And it is necessary when your estate is over 15,000. If you don't have estate up to 15,000 or under 15,000, you don't need to worry about it. But I highly doubt here anyone who has assets less than 15,000. Your home alone is worth more than that. So it is something that you need to consider, that it is going to be probated if you pass without defining your last wishes. And it is an expensive process. The probate process itself is expensive and lengthy. It runs into years. Once your home gets stuck in the probate process, a realtor cannot look at it. A realtor will not touch it because it is in the probate process. They have to wait till it's completed, the probate process, and appropriate authority has been granted to the executor. Once you open up a probate, typically an attorney will cost around $2,000 to open up a probate process. And it also will depend on the outcome during that process. God forbid if there is litigation around it. You have family members that are contesting for things and, filing lawsuits against that. So if that comes into play, the cost can escalate because you are involving a state attorney in litigating for you on top of the probate process. So how can we avoid probate? So one of the things that I want to clarify is that there's no way that you can completely avoid probate. You have to probate, but the idea is to minimize interaction, to minimize probate interaction with Georgia courts, because that will make it fast and that will make it easier on your loved ones who are left behind. So there are several tools that are at your disposal that you can use. You can have, one of the biggest tools is you gift everything in advance during your lifetime. You can do that too. If you do that, gifting during your lifetime, that is called hiba. In Islamic terms, it's called hiba. It's not considered wasiya. However, if you have interest in creating a wasiya, then you have to go through this process of creating an estate plan and choosing the right instrument, because there are many instruments available to estate planners to create a plan for you. You can have joint accounts. You can have named beneficiaries on your accounts. You can have pass on death and transfer on death instructions for a lot of things. For example, you can have on your 401k account, you can have an instruction that on my death, this is what I want the proceeds to be given to. And you can name anybody that you want, basically on that, your children, your spouse, another LLC that you created for keeping all your assets, or your trust, or any other entity that you created. So that's why it is important to understand what are the kinds of things that you should think about. For example, what is your strategy? Is it distribution of your wealth to your beneficiary? Is it about planning for end of life, where you have medical bills and you want to make sure that your estate is not eaten up by the medical bills, third-party creditors? Or is it asset protection? So those are the kinds of questions that you must answer in order to have a robust estate plan. Just writing, an estate is not sufficient. Having a robust estate plan is really important. And obviously, if you don't have any of that instrument, not even a will, what Georgia law is going to do is that it will use a table of consanguinity, and that's one of the ways it determines who the heirs or the beneficiaries could be if you don't have any named beneficiaries. And the worst part is that if there's nobody, then it goes to the state of Georgia, and that's called escheat of that asset category. So, as I mentioned, the goals are basically that the first and the foremost goal is that you minimize trouble for your loved ones who are left behind. You clearly stipulate your end of life decisions, your treatment preferences, your distribution ratios, your charitable gifts, all those things that need to be clearly stipulated. And then you want to minimize court intervention as much as possible. So that is why it's really important to share this plan with the rest of your family, share this plan with the trusted individuals that you are going to give the responsibility of administering your probate assets after you're gone. It's very important to clearly communicate that. Also, think about healthcare needs. For example, God forbid, if you end up in a hospice or in long-term healthcare, what are the things that you can do to mitigate the risk around that? Because it's very expensive here to get old. That's one thing for sure. It is an expensive proposition here. So as I mentioned, there are multiple tools that are available for creating an estate plan. Will is one of the tool that is available. Durable power of attorney is also one. There is a living will that you can have. You can have trusts, and there are various kinds of trusts, like special needs trust. If you have somebody who's a special need person, irrevocable trusts. If you want your assets to be in a sort of like in an ironclad lock where you don't want anyone else to access them except for the people that you have identified as beneficiaries in the trust. And then there is also revocable trust. So revocable trust works 99% of the times in situations because it provides you the flexibility that a revocable trust offers, plus it offers a provision where you can manage and be your own trustee for that matter. So once you've decided what your goals are, then the next step is to identify what is estate and what is not estate. So your estate plan covers your personal estate. So you have to understand the difference between a personal estate and items that are outside of your personal estate. Like, for example, 401k retirement accounts. They are not considered as part of your personal estate. Reason being, it is your money, but the reason being is that you have identified a beneficiary for it. It is earmarked for that beneficiary. When you pass, that beneficiary is going to receive that. Similarly, insurance proceeds. Insurance proceeds also have beneficiaries earmarked. And there are ways that you can make sure that it is saved from third-party creditors, because one of the biggest problem is that people worry about in their retirement years is running out of money. When you accumulate medical bills or other kinds of bills, it is possible that you can run out of money really, really fast. So that's why asset protection should also be one of your goals, to make sure that the wealth stays within the family and not goes to outside of that, like IRS or maybe a hospital or whatever. So let's take revocable trust a little bit more in depth. The revocable trust is one of a very common form of instrument that people like to use, partly because of the flexibility it provides. The flexibility offered is in terms of identifying the rules and the ability to change them, identifying beneficiaries and the ability to change them, and then the amount of powers that you want to give to that special person who you identified as a trustee. So think of it as a three-way relationship. So you have a trust maker, you have beneficiaries who you want to benefit from this, and then there is this third person called a trustee, which has a fiduciary responsibility towards making sure that whatever the trust maker has identified for the beneficiary, he follows it to the dot. He or she follows it to the dot. Fiduciary relationship means that that person has to put the trust's interests before their own interests. It's a legal obligation to make sure that that duties are fully met. That's why it's really important to choose a person who is trustworthy and will follow directions Otherwise, you might end up in court litigating and making sure that everybody gets the needful. You can also put in rules in your revocable trust that this kind of condition will freeze that trust. No changes can happen after that. That means that it becomes irrevocable after that. The other good thing about an irrevocable trust is that it's passed through taxation. You do not need to get an EIN number from IRS for filing taxes for it. They will be just like an LLC or S corporation. However, it is an entity that is separate from your personal estate. So you do get the benefit of an independent entity, but yet you get that benefits of pass-through taxation in revocable trust. And typically the cost for creating a revocable trust is between $2,500 to $5,000, which in fact, it comes out to be much cheaper in the longer run if you end up in probate court and litigate. That could escalate pretty quickly. And then obviously there are other kinds of trusts that you can make. You can have irrevocable trust, special needs trust. If you have a special needs child or somebody who has that kind of a requirement, you can also create your own legacy by creating a charitable trust, giving charity to a nonprofit that you really want to support. And then the last one is a testamentary trust, which in fact is a very special kind of a trust which comes into play when you pass. And it is usually incorporated within your will, that you create a trust within your will, and that's called a testamentary trust. So as I mentioned, when you give away assets during your lifetime, it is called hiba. But for passing your assets after you die, for that you need a will or some sort of an instrument to pass on these assets to your progeny, or to anyone else, because the distribution can be based on not just on inheritance, but also on need, also on service. If somebody takes care of you on your deathbed and you want to reward that person with some money, you can do that in your will. A lot of people do that. So you have to keep in mind that there are provisions and there are various reasons for giving out money to people. Either there are your blood relatives, your children, or somebody else who took care of you. So once you have passed and your estate is ready for administration, the whole process is called estate administration process, and basically that will be carried out by your executor. You'll have to name an executor who will go through the stipulations or the way you have identified your distribution ratios in your will and make sure that they are completed as stated in the will. However, there are certain things that will still need to come out from your personal estate for you. For example, like your gravesite, your kafan, your ghusl, any of those things, it is preferred that it comes out from your personal estate. So think about that. And if you're unsure whether your wife's meher is paid, then you better make sure that it is paid, because otherwise it will come out of your personal estate on your passing. Meher is also considered a debt against personal estate. So in terms of blood relatives, the inner circle in Islam is the parents and children. And then, of course, if those are unavailable, we go out to the outer circle, which is siblings. As you can see, there are siblings and their children and grandparents. And then if that is not met, you go out to maternal uncles and paternal uncles and aunts. So there is a method to this madness. It's not very arbitrary. And they are considered first degree, second degree, and third degree. So in conclusion, the estate plan is basically a set of tools that you have put together to make your end of life easier for the people who are left behind. And then the decedent's executor is responsible for making sure that they are carried out. So if you are an executor of a will, it's a hefty duty. You have to make sure that you follow through on what the promises you have made, because this is going to be an important conversation when you will appoint somebody as your executor. And in every step of the way, what is important is that you communicate. You communicate clearly with your children, with your spouse, with the people you are putting this responsibility on, that they are aware of it and that they know what they need to do. That's very important to communicate. So I guess we're on to questions and answers. That concludes my presentation.
You did it. Yes.
Hello?
Hello, everyone. Welcome again back to the question and answer session. So this can be in Bengali or English. Just feel free to ask in any way, in any language, and we'll muddle through.
So before we begin, I just wanted to make sure that I make this announcement that inshallah, if you decide to choose us and come through us, we will donate 15% to Seba Library for all the proceeds.
Wonderful. So everyone knows, right? If you avail her services for wills, trust, estate planning, and everything related, 15% of the donations will go to Sheba. Thank you. I just wanted to make sure everybody heard that. Emphasizing. So who will take the first question? Okay.
Ma'am, thank you for coming here. I have a question. In fact, two parts. One already answered. You already answered. You can guess what was that question. Okay. First thing, if I understood you right, you said that any property left more than 15K must be routed through probate system. That means, in other words, we all have to make some decisions in a legal manner. I'm making it a little longer because I have a feeling some of our friends is a little bit confused on some of the things. That's why I myself am. So I have to make sure that I got it right. That's number one. So we all have to do something. Now, I was kind of confused when I first saw the Islamic will. So, but now I understand what you're saying basically is we will make a will or trust or whatever it is as per the law of the land in here, and if we wish to incorporate the Islamic things there, then we'll make the distribution accordingly, right?
Correct.
Okay, I'm a little speech impaired, so please bear with me.
No worries.
Okay, so basically it doesn't mean that it has to be a traditional so-called Islamic will. It's just we put our wishes fitting to this structure of this legal system here. And third thing you said that we can have it different forms. You say something irrevocable and revocable. Basically what means we can change it? We cannot change it. And you say some advantage of the revocable ones. I would appreciate if you spend a minute on explaining what is the unique advantage of revocable one. Mostly we know that. What is the disadvantage of revocable one? The irrevocable one means it is done. Revocable I can change. I made my mind today. I'll give everything to Molly, and then tomorrow Molly didn't say hi to me. I get mad. I say, hell with Molly. I give it to Jolly. Right? That's revocable. So, but there must be a disadvantage. What is the disadvantage of that? Thank you.
So let me just start from the very beginning, iterating your first question about maximum estate limit. You understand it correctly. If your personal estate, the keyword is personal estate, is more than 15,000, then you have to probate your assets through the court. This is Georgia law. If it is less than 15,000, nobody cares. You can give it to your next door neighbor or whatever, how you want to do it. But tell me who in this room has assets less than 15,000? Your car alone is probably worth more than that. So in reality, what I'm saying is that almost all of us have to think about this, that our assets will have to be distributed through a probate court. Question number 2 about differences between revocable and irrevocable. No, sorry, it was about Islamic will. So the idea is that we need a legal document that will stand in Georgia court today. If you live in Georgia, you will need a legal document that will stand in Georgia court for your distribution. And the only way that you can do it is that it has to fit all the requirements that Georgia law puts on it. Again, there could, depending on the type of instrument you choose, you have to follow the letter of the law to the dot. The word Islamic estate comes into play here, and I know a lot of people get confused about it. It is basically what it's talking about is distribution ratios in a specific manner to your beneficiaries. Besides that, there's nothing different about Islamic will. The requirement for having 2 witnesses, same as Georgia law. Requirement for having capacity, same as Georgia law. Requirement for being 14 years and old, same as Georgia law. So there are a lot of similarities that are present in Quran, which are again present in Georgia law for creating a will. So that's what I'm saying, is that create a legal framework according to Georgia law, which incorporate Islamic principles. That's basically an Islamic estate planning. Number 3, differences between the types of instruments. As I mentioned earlier, you have wills, Again, wills are of different types as well. You can have a joint will, you can have a mirror will, you can have testamentary will. So these are the kinds of things that unless you educate yourself, you're not going to know the difference. And sole purpose of coming here is to educate the community, to make them understand that, okay, yes, this is another type of solution that might work for your situation. So so that's the whole purpose, to just shed some light on possibilities that maybe you haven't thought about. Maybe you haven't even considered that you can solve this according to this flow, or these steps. So I think that's what's important, because it's not a one size fits all. You cannot say that, oh, Al Farouk has a form for creating a will, I'll use that. But in reality, if you look at that form, it has so many ambiguities. It's not going to stand in Georgia law at all, in a court today, if you do that. Your probate judge will either throw it out, or, ask the executor and the beneficiaries to come in and answer questions and answer those ambiguities. So that the goal here is to minimize probate court's intervention. And that's why you need to work with somebody who is professional and who understands the Georgia law. The benefit that you get with working with me is that I understand Islamic law as well. So if you have that need or desire to incorporate Islamic principles, I can help you with that in a manner that the court will understand.
Yeah.
One thing I wanted to clarify when she said Al Farouk, because it took me just a second to understand what she was saying, is that Al Farouk is actually the mosque. So if the mosque has a form and you fill it out, that's not going to stand in Georgia court. So probate will throw it out, or as you said.
Thank you. Thank you for clarifying. Yes, exactly. That's what I meant. And they have, I think on their website, they have a canned form that is available to anybody. But again, what's it worth?
Yeah. But I think they should clarify if they have that.
Thank you for coming in and giving us the important information. I have a confusion between trust and will. So my bank accounts are joint with my wife. My house is joint with my wife. 401k has a nominee, and all my asset is joint. I still have a will at home that I prepared myself. Like I learned today that I should go a professional.
Mm-hmm.
But what is the best way to, after my death, for my children and my wife, is a trust? Doesn't matter recoverable, irrecoverable, but what I'm trying to say, like, should I just do a will and that'll be enough for the probate court, or I should do a trust?
Very good question. So a lot of people conflate many things in terms of requirement for will. You can never get out of the requirement for having a will, because that is Georgia law. You have to. The idea here is that you minimize that interaction as much as possible. If you want to expedite distribution and follow certain guidelines that you have put together in your lifetime, you want to be able to create a document outside of that will that is going to give all those kinds of instructions to your trustee or the person that you have chosen to administer your will, that what is my your burial instructions, your distribution of your assets. So the thing is that if you have a will, so first thing is that you cannot get out of having a will. You will always need a will. Second aspect is that if you combine your will with an irrevocable estate, what advantage you will have for doing that is that immediate access. Your loved ones will have immediate access to your assets. They will not have to wait for the probate court to give authority to the trustee, because the trustee already has that. You've given that authority to the trustee in your lifetime. So that is one thing. The other thing is that you also have to think about tax treatment of the assets when, or the income that your beneficiaries will receive, because nobody talks about that. If you give $1 million to each of your child outright in your will, what happens at the other end? What happens to your child? Poor guy is stuck with feeding Uncle Sam for at least 30% of that tax bill. So you have to understand the tax treatment that will happen with using instruments like will. So anytime that you have outright distribution, regardless of even with your 401k distribution, this is exactly what's going to happen, that they will receive an outright distribution of the proceeds from the 401k. And long and behold, Uncle Sam is there to get his cut. So the planning should also take this into consideration, that you need tax protection, you need asset protection, and you also need immediate access for the people who are left behind. For one more example, let's say you have an individual account, individual bank account without any POD or TOD. That account will get frozen at the bank. No one can access it till your will is probated. So those are the kinds of things. The same goes for a locker. If you had a will and you kept it in the locker, no one will ever get to it. That's the other thing, is that how will you probate something that is completely frozen?
So that's where the communication comes
Yes,
in, right?
it's very important. Very important.
Good afternoon to all. Thanks for coming. Sorry. Can you hear me now? Okay. I have a two-part question. So.
Can you come forward? Is it okay?
Okay, thank you. So, I did my living will done in 2016 in New York State. Mm-hmm. So I moved in here 2019. Mm-hmm. So do I need an amendment, or I just can change my current address with the notary will do?
So let me understand the scenario here. So you have a living will.
Yes.
So the living will, another name for the living will is an advanced health directive.
Yes.
Right?
Living
Which
will
is not the same thing as your will.
Yeah, I do have also will.
You also have a will,
yes.
Right?
Yes.
So you have probably two instruments.
Yes.
You have a will, mm-hmm. And you have an advanced health directive.
Correct.
Does that also cover financial aspects?
Yes.
Okay. So
yes.
It's more like a power of attorney, durable power of attorney.
Vice versa to my wife and me.
Okay. So again, the problem that I foresee here is that, the jurisdiction is completely different
Correct.
now. Your instruments were made in New York, in that
right.
jurisdiction.
Uh-huh.
Sometimes they can be brought over, But what I would recommend is that you create instruments that are appropriate for this jurisdiction, for Georgia jurisdiction, because the laws are slightly different in terms of taxation, asset taxation.
That's right.
So I would recommend that at least have somebody review it,
Review the whole thing?
Yeah, review it.
Okay. How about the healthcare proxy is like a living will? That's the same thing?
Right, exactly. So the Advanced Directive for Health, or another word for it is living will.
Okay.
It basically covers your health directives, your treatment preferences,
Right.
your autopsy choices, your, anything that has to do with health decisions when you become incapacitated.
Okay.
And you identify a person who is your healthcare agent, and basically he will step in your place and then make those decisions for you, and that's called a living will.
That's right. Okay. Second part is, how about that benefit, like IRA, or trust? I have some annuity, all other stuff.
Right.
So the New York State and Georgia is almost the same in the whole United States. The law goes, the federal law?
So it depends on the original contract of those retirement accounts or annuity accounts. If they are governed under New York state law, then the New York law will apply to it.
Okay.
But the thing is that any of these kinds of instruments are outside of your personal estate, because you've already designated a beneficiary in those.
Yes, I do. Yes.
So at your passing, the proceeds will be outright distributed to the beneficiary that you have assigned. Again, remember, if one thing that you want to get out of this seminar is that outright distribution is going to trigger tax. That is one thing that you need to...
So that's my another question was, New York State has a different kind of law for income tax, even federal, state, and local. Same goes in here too, right?
Well, there will be tax, but I think Georgia law is a little bit more favorable when it comes to income. But again, if the annuity is managed under New York law, the New York taxes would apply to it.
So what I should do? I just changed it.
So the way to get around that problem is to, instead of outright distributing to an individual, you assign it to a trust. So then there is no...
Trust is my son's, correct? Or the law firm?
So trust is an independent entity that is legal and binding, and it's something that you create. And usually it has, a bank account associated to it. So the proceeds can go into the trust. That way, they can be held for your beneficiaries in further trust, in descendant trust. So they don't have to pay outright taxes.
We'll mention that my beneficiary, both of us passed to my son, equally distributed 50-50. So the beneficiary to both my sons.
So you can identify that in the trust. So don't confuse that with will, because will has no bearing on your annuity and your 401k. Will
Even
has
my
no
bank
bearing.
account.
So your bank account is a different story.
I see.
Your individual bank account is a different story.
Okay.
Your retirement accounts are different from your individual. So think of them as separate buckets that are governed by, different rules than your individual accounts. You can stipulate there that I want the distribution to be 50-50 to both my sons. But the problem that I'm trying to identify here is that your retirement accounts will be outright distributed. Let's say you have $1 million in your annuity or your retirement account. each of them will get 500,000, and then it will be reported in the year on their 1040, right?
Mhm.
So they will have to report that 500,000 each of them on their 1040, and then 1040 will ask for taxes.
That part
on
I
that,
understand.
unless you put it in trust.
Yeah, I have to. So you suggest to create a trust much better than the way it is.
So if you want to avoid outright
See,
distribution,
I don't work anymore. I took early retirement.
that's okay. That's okay.
So
You so
that's okay.
creating.
Thank you so much.
Thank you very much for valuable information. So I have a few questions.
Sure.
First of all, let's say, is the price is for both husband and wife, two different trust or joint account?
So the trust can be a joint trust or an individual trust. It's completely up to you. You can create a joint trust with your wife as a trustee and a co-trustee. That is also possible. Or if you decide to do that individually, you can both do individually. But typically that's what happens between couples. You know, they come to me and then I suggest that you do a joint trust. Similarly, there is option that you can do a joint will as well. But remember that you will run into the problems that are typically associated with just having wills without any other instruments associated to them. The best way, in my opinion, is to create a joint trust and then two individual wills that are called pour-over wills. Basically, what each of them is doing for you and your wife is that redirecting all your assets to the trust. And that's why it's called a pour-over will, which is simplifying, probate process and making it as easy as can be.
Okay. So what price you have set up, like 2,500 to 5,000 range, that covers both husband and wife?
Yeah. So typically, what I offer is I offer an estate bundle.
Correct.
An estate bundle consists of about 8 or 9 documents, which consist of a trust, which can be revocable or irrevocable, certification of trust, your advance directives, both health and finance. What I recommend to do is that you have advance directives separated out between health and finance. Don't conflate it, because you only want to give the power enough for the person to do the job, not more than that. And then additionally, you will have 2 pour-over wills. And if it involves a primary residence, then a quitclaim deed to actually transfer the title of your primary residence into the trust. So that comes with your estate bundle.
Got it. Thank you so much. Another one is, let's say I did the whole bundle from you, right? And after 1 year, I moved to state of Texas. Now, do I get a hard copy from you, or I get a digital access also to change anything if I want?
So you will only get a hard copy from me at the time of execution of this trust. If you want to change anything, what you would need to do is to add an addendum to your trust document. It's a binder, about 200 pages. You will get that. And you can add an addendum, get it signed and notarized, and you're good to go.
Okay, so, yeah.
Did you get your answer? Your bundle?
Yes, yes. Yes. I got it. Thank you. So if I get the amendment, do I get it now or after 6 months if I need it? Do I come to you, or how it works?
So one thing that you must understand is that the way the trust is structured is that there is a role called trust protector. That trust protector has the power to change the situs of the trust. For example, you decide to move from Georgia to Texas. The trust protector can now say that the law of state of Georgia is no longer applicable here. I'm going to change the situs of this trust to Texas, and that will be, an amendment to that trust. So it can then be executed under the state law of Texas. So there are all these provisions that are built into the trust document that allows you to move from one state to another. But if there is any conflict, then the Georgia law will answer that conflict.
Okay, so one more thing. I'll do it short. So let's say I'm not moving into Texas. I'm here, and after 1 month or after 1 year, I need to change something, amendment or address change, or I sold one house and I bought another one, and I would put that in the trust. How it will work with, because I already paid and I got my whole package with me, everything is done. So what would be the cost?
So for a real estate to be included in the trust, you typically will need to take the title in the name of the trust. So you can do it at the time of the closing of your house or your whatever real estate that you're buying. You make sure that you take the title under the name of the trust. If you fail to do that and you took it under individual capacity, then you will need to submit a quitclaim deed to state of Georgia to say that I want to move this property into my estate. And we can do that, or you could do it yourself. It is something that will require some attention from you, in the sense that it's not something that it's just a piece of paper and that's it. This requires intervention from state of Georgia. So personal property treatment is slightly different.
Or just like any basic amendment, if I want to do it after 2 years, how
So
it works?
basic amendment, if it doesn't require intervention from county assessor or whatever, all you have to do is to write up that amendment, sign it, make sure that the trust makers, all the trust makers have signed it, the trustee has signed it, and get it notarized, and that should be sufficient. But again, it's going to depend on the type of amendment you're looking for, right? If you're looking for an extensive amendment, then there are rules governing that.
Okay, so let's say I'm a lame, I don't know anything, right? I did it and now I need help. So I don't know what is amendment, I don't know what to write it. So just, do I have to come to you? Would you charge it, or do I have to go to someone else?
We can absolutely help you draft that. And depending on the type of amendment, we can provide you a code for it.
And with the same price, right?
Yes.
What I paid for.
Not the price of the original estate
I
bundle.
got it.
So it will be whatever the amendment that you're looking for, and it's going to be on a case-by-case basis.
Thank you so much.
Depending on the
Yeah.
on the work.
Yeah.
Hello. First of all, thank you for coming. And being myself as a computer engineer, I'm a little intrigued by your background, having a computer science and then become a lawyer and helping us. So thank you. The question I have is, am I understanding it right? Does not matter whether I have a will or trust, still I have to pay $15,000 fee? No.
No.
Okay.
No. So 15,000 fee, I don't know where that number came from. 15,000 is the value of your personal estate.
Okay.
That if you have estate more than 15,000, Georgia law says that you have to get it probated.
Okay.
That's the threshold.
Okay. Thank you. So another question I have more from my personal perspective. So I have a will, then I have a financial directives, and also have a health directive. Then I have a living trust created. But these are created when my child was a minor. So there's some of those provisions built into that. So now he's an adult. So do I need to change all of these because of that implication, or I can just stay
No,
as is?
I don't think so, unless you are changing the structure of the will of your trust in any way. I don't think that you need to revise it just because the child has reached the age of majority. I don't think that you need to do that. However, just remember, God forbid anything happens to your child and he has his own children. You have to make sure that all that progeny is included in your structure, trust structure. So again, it's going to depend on the language that was used in the trust. At that time, there was no provision that you will include your children and their children as well.
So it is better to get it reviewed, I think.
Get it reviewed. That's what I would recommend. And if there is an additional amendment needed, you can have that done. So again, it's going to depend on the language and the trust.
So I have the last question. I think some of us also have the same questions. So because of this digital age, we hear these digital services. The big one is legal Zoom. I think you are aware of that. And sometimes they say, okay, we will do things for you for pennies. So here we have the professional organization and coming up with different kind of packaging. So how we differentiate and how we know which one has what kind of values?
So let me tell you a story. One of my clients came up to me and he brought a digital version of a trust that he created online. And when I reviewed it, I found that his primary residence was not even part of the trust that was created. So remember, Georgia is a deed state. If you do not have a deed conveying the title remains the same. So that was one flaw. And then there are other provisions that we typically include in our trust structure. There is something called annual gift tax exclusion. Every year, you have the ability to give $17,000 tax-free to whoever you want to gift to. If you do not put those provisions in your trust instrument, you can't use them. So that means, in a sense, it's wasted. It's up to you to use them, but not having them and not even knowing about them is worse than not using them. You can know about it and decide not to use it. But I think what I'm trying to tell you is that a lot of provisions that online trusts do not have are things that protect your assets better and help you use the IRS provisions that are available to everybody free of charge. The only problem is that not a lot of people know about them. Did you know about annual gift tax exclusion? So that's exactly why I suggest that you find somebody who's professional and who can do it. Yes, online trust will create a document for you, but at the end, you'll get this rude awakening that your house is not even in the trust because you didn't have the right instrument to do that.
All right. Thank you very much.
So best way, if you consult me, and what I offer is that I offer an hour of initial consultation free of charge. That meeting basically can be done virtually. I can do a Zoom meeting with you. And that is when I find out what your objectives are and what are the most suitable instruments to answer your needs, your immediate needs and long-term needs. So that is basically an exploratory meeting. And then once we have defined what you're looking for, we can start the drafting process. And of course, we can discuss the fees and whatever at the time. We'll send you an engagement letter. You sign that engagement letter, and then we create the draft for you. You review it, you approve it, and then the last part is the execution process where you have to sign it.
I have one weird question. I tell you, I'm loud enough. My question was,
I think some of these assets or antiques or emotional values attached to my books or some rugs or some antique stamps or I think it has a value, but my children think that these are trustable. So, but I still feel that they might be valuable at some point in the future, like 10 years or like that. So what do I do about this? I cannot make a tangible figure or price for it.
So let me start from the very basic foundation. So there are two types of properties: real property, personal property. Anything that has to do with land is considered real property. Anything that is not land is personal property. What you just mentioned is part of personal property, and that is absolutely as important as real property, because not because it has nostalgic value or it has, but it has really value, because they say that anyone's trash can be anybody else's treasure. So so what I would recommend is that you create an inventory of your treasured items. You make that as part of your estate bundle, and you can think of people who you want to give it to, and then put their names in there. If your children don't want it, there are a lot of other people who will be willing to accept that gracious gift.
So I have a question, and I think we touched on this before. I just realized before this I didn't even realize it, but we have assets in different states for whatever reason. Okay, New York, Georgia, and whatnot. Anyway, so for various reasons, it happened that way. So now we primarily live in Georgia. So what happens to our estate, the assets outside of?
So the beauty of a trust is that it can hold assets outside of Georgia as well. The key thing is that you have to look for a jurisdiction that accepts U.S. contract law. And I would hope that New York will accept U.S. contract law. If it doesn't, then we're in trouble.
Yeah.
So you can put all your out-of-state property in your trust that is governed by Georgia law.
What about international?
So international is a little bit tricky, partly because of the jurisdiction that you're in. If the jurisdiction accepts U.S. contract law, for example, any place in Europe or some parts in Middle East, they also accept U.S. contract law, then I think you are in a good spot. But places like Pakistan, I know I have a problem. They don't accept U.S. contract law. They use their own law. Yeah. And that's why I would not recommend putting those assets in your trust. You'd probably better off using the local law for that.
Local law.
Yes.
Okay. She has a question.
Yeah.
Sure. Yes. Yes, absolutely. Not a problem. Yes, ma'am. Can you come forward, please?
So let's say I've got some people in Bangladesh. I want to send them either items or maybe money. Oh, okay. Items might be more difficult, or I might want to send money or something. I'm not sure. So how would that work? I guess the most easily, maybe.
So sending money, going out is not going to be part of your personal estate, because are you talking about gifting? Is that what your question is about? So is there something that you want to use the annual gift tax exclusion for? The problem with annual gift tax exclusion is that it needs to be claimed on the receiver's 1040. And the gifter has to file Form 709 with IRS to claim tax exemption.
So let's just say, I've got,
But there needs to be a paperwork and, chain of custody on either side to establish that.
okay.
But you can, if I remember your presentation, people can do the gift while they're still alive. I mean,
Right, but this has so
oh, the tax.
so there is no tax implication. You can gift anyone anything in your lifetime, right? And that doesn't help you in any way.
Anyway, because
because you're
gonna have
not
to pay
getting
the
any
taxes first.
right.
And then, if you're giving a gift in your lifetime,
Uh,
does it
well,
make sense?
yeah.
Yeah.
My question is like a supplementary question to her actually. What if I have assets in international, anywhere in the, say for Bangladesh, yes, say for example, in Bangladesh. How do you address that into my will?
So you have property in Bangladesh. Is that what you're
Right.
Okay. So you have property in Bangladesh.
Properties, bank accounts, whatever. I mean,
Right.
assets.
Right. So again, as I mentioned, this is international assets, right? So international assets that are governed under local law, as long as the local jurisdiction accepts U.S. contract law, you can do that. But if it is beyond that, then typically what I recommend is to use local law to, and whatever that needs, whatever you need to do in terms of local law to retain ownership for that, you'll need to do that. If you want to sell it and bring the proceeds over, then there is something that you can use, which is called a lifetime exclusion gift. And the amount that you can bring gift free into a trust is about 1.5 million.
But Bangladesh doesn't allow.
Since everybody is complimenting and supplementing, let me supplementing also.
Bangladesh doesn't allow
Right.
money coming out
Yeah.
legally.
Right. Right.
So that won't work.
Okay, go ahead.
Okay, thanks for coming. It's a very small question, but we came to learn lots of things today. So my question is, for example, I have 401k and Roth IRA, everything is set up, and beneficiary also have been set up. And then I have done the trust today with the amount of money we have. And then, for example, we bring out or cash out the money for any emergency situation. So then do we have to update the trust again?
So let me understand your question correctly. You have retirement accounts that have proper beneficiary designation. Is the trust a beneficiary of the retirement accounts?
Have not made yet, but after talking, learn from you.
Okay.
For example, I made a trust.
Okay.
Okay.
So the value of the retirement account has no significance on the instructions that have been provided. If you took something out and there is nothing there, then at the end, what will happen to that document is that it won't be applicable. It's not going to make that document invalid because there is nothing in the retirement account, but it's just that it's inapplicable because there is nothing to act upon. So there are a lot of provisions in the law that the clauses will only become active if that condition is fulfilled. So that's why it is, it says that we've covered all our grounds. So I don't think that there's going to be any change needed on the structure of the trust. The only thing that you need to make sure is that the beneficiary designation is amended and includes trust.
Okay, thank you.
Yeah, when you make the trust.
Yeah.
Sorry.
Thank you for valuable information. I got a quick question. So I have a trust. My children are beneficiary and wife. Children get adult. They get married. Year down the road, they get divorced. Now, is there a way to protect that money not part of the divorce settlement?
Absolutely. Till the time that, so the way typically trusts are structured, the beneficiaries don't have anything until their individual trust gets funded, right? So today you just have a structure where you've identified that these are the beneficiaries, but there's nothing that has been funded for them yet, right? Because you're still alive, right? If it would have happened at a time that you had passed and their individual accounts were funded, then yes, you can say that the divorce settlement can have a claim on those assets. You have to understand that funding of a trust is also very important. You can create a trust and you cannot and you haven't funded it. Then that means there's nothing in that trust. So there are two separate steps, creation and funding. It depends on how your trust language stipulates the distribution and the funding process of your descendant trust. That will play a big role in determining whether the divorce proceedings will have any effect on it. Typically, this would be considered third-party creditor, right? So we avoid third-party creditors by saying that this is a descendant trust, which is completely protected from any third-party creditor claims. But again, this is as ironclad as it can get. There are ways a lot of people can go around it by submitting claims against it, getting into litigation, and hiring lawyers who will present their cases, and it could go either way. So the thing that is important is to make sure that the descendant trusts are named for the beneficiaries, and then there is provision for protection from third-party creditors.
Thank you.
Any more questions? Hello? Any more question? Last question? I think we are done. Okay.
Thank you very much.
So much. Thank you.